Good evening, everyone, and welcome. My name is Laurie Facciorosa-Brewer, and I am the State Long-Term Care Ombudsman for the state of New Jersey. I'm so excited to present tonight's presentation, Common Nursing Home Problems and How to Solve Them. We are so honored to have Eric Carlson, who is a national leader on these issues, joining us today. We are co-sponsoring this webinar with our other wonderful partners at FACE New Jersey. So right now I'd like to turn it over to FACE New Jersey Director, Laurie Kuthoff, who can talk a little bit about their organization and our partnership before I come back and introduce Eric.
Welcome, everyone. My name is Laurie Kuthoff, and I am the Director of FACE New Jersey. FACE stands for Family Advocate Care Experience, and we're a private Facebook group comprised of over 1,400 caregivers or family members of loved ones living in long-term care facilities. FACE New Jersey was founded by Bill Borelli back in the summer of 2020 as a result of seeing the impact that isolation had on his mother due to the facility lockdowns. FACE New Jersey was formed to end the isolation and to restore visitation rights. We started to advocate by writing emails and letters to the Department of Health, sharing the stories of our loved ones. We knew that we had to be their voice and that we were more than just visitors. We provided more than just physical care. We provided mental and emotional support that they so dearly needed. We worked to address issues that our members were having, and we were very fortunate to have the tremendous support from Laurie and her team at the Ombudsman's office to help our members resolve issues. At the one-year anniversary back in March of 2021 of the lockdown, we took our message of 1 year, 2 shots, what next, to Trenton. We held a peaceful rally. We had a lawn sign campaign across New Jersey at different locations that said isolation kills too, because we knew that there was an impact of that. And we hosted a memorial service to remember those that we had lost during the lockdown. FACE New Jersey has and continues to support efforts to pass federal legislation known as the Essential Caregivers Act, HR 3733. We went to Washington, D.C. when the bill was introduced, and we continue to work to move it forward. We're also working to pass state-level Essential Caregiver Act in New Jersey. Our core focus has been on visitation rights, and we'll continue to advocate for those, but with the support of the LTC Ombudsman's Office, we've been able to support one another on other issues. The COVID-19 pandemic exposed many issues in the industry, and that's why tonight's webinar with Eric is so important to us. I appreciate the partnership with Laurie and her team, and I look forward to the information that Eric is about to present. If anyone would like more information on FACE or would like to join, you can find us on Facebook. Just look up FACE New Jersey, and we are certainly welcoming new members. And with that, I'll turn it back to Laurie.
Thanks so much, Laurie. Before we proceed any further, I want to let you know that Eric is going to be making his presentation, and we will take questions afterward. You can certainly put them under the question function throughout the presentation, and we will do our best to get to any questions at the end. So without further ado, I just want to introduce Eric Carlson, who has broad experience in many forms of long-term care services and supports, including home and community-based services, nursing facility care, and assisted living facilities. He led Justice and Aging's extensive research on Medicaid-funded assisted living and currently is leading a project to assist consumer advocacy on Medicaid managed care MLTSS in Florida and New Jersey. He counsels attorneys from across the country and co-counsels litigation on consumers' behalf. Mr. Carlson serves as president of the National Assisted Living Consumer Alliance and is author of the legal treatise Long-Term Care Advocacy. His state bar admissions include California, Northern District of California, Central District of California, and the Ninth Circuit of Appeals. Again, we're so honored to have you, Eric. Take it away.
Thanks, Larry. And I'm really pleased to be here. The presentation this evening focuses on common nursing home problems. The message is that these are very common problems. You see them all the time. but they have some strategies as well that allow people to deal with them as long as they can be recognized. Justice and Aging is a nonprofit organization. We focus on legal issues that particularly affect older Americans with limited resources, with a focus on healthcare, income, and housing as well. We do, so as suggested by my own bio, a variety of different things, all designed to benefit low-income older Americans, including, but not limited to, litigation, administrative advocacy, research, and is particularly relevant this evening, education. The rules in nursing facilities are set by a federal law that applies across the country. The nursing home reform law applies to any resident of any facility that accepts Medicare or Medicaid, regardless of the individual resident's source of payment. So as long as the facility is certified to accept either Medicaid or Medicare or both, then it protects everybody in that facility. And as a practical matter, this is almost every resident in the country. Maybe there's 2 or 3% of the facilities that have such a wealthy clientele that they can afford to turn their back on Medicare and Medicaid, but that's just a tiny sliver of the facilities that are out there. So in general, with these very limited exceptions, what I'm saying today is going to apply to every resident of every nursing facility. And there are 2 core principles that I would suggest that you keep in mind. We'll return to them with a quick pop quiz at the end of the presentation. The first principle is that the nursing facility has to provide the service that the resident needs to reach the highest practicable level of functioning. So in other words, it is inappropriate for the facility to throw up its hands and say, well, you know, what can you do? People get old, they get sick, that is inappropriate. The facility has to do whatever it can to get the resident to the highest practicable level. And in some cases, that means that residents will improve. In some cases, it means that residents will stay more or less where they are. And in some cases, it may mean that residents decline a bit, but at a lesser rate than would be true if they hadn't received that particular level of services. So that's principle number 1. Principle number 2 is there shouldn't be any discrimination based on payment source. And specifically, there shouldn't be any discrimination against Medicaid eligible people. So whenever in a nursing facility you hear something along the lines of, oh, we can't do that because this person's Medicaid eligible, we don't get paid enough. Wrong, wrong, wrong. The facilities have promised to provide equal level of care to Medicaid eligible residents, and so they are required to live up to that promise. This idea of common problems is based on common misstatements. I've been doing this work for a long time. When I started, I observed that I'd see some of the same things over and over again in the same false statements. And so I started doing some presentations, originally 5 lies told by nursing facilities, 10 falsehoods, 15 myths, and then I've expanded it to 25. And if I felt like it, I'm sure I could increase it to 30 or 35. But the idea is this, that people in nursing facilities, residents, family members, hear things from facilities that are just flat out wrong, that are a misstatement of the law. They're saying, oh, I'm sorry, we can't do something, but in fact, that's not true. They have to do it. And we'll talk about examples like this during the presentation. So we've set up this presentation and this consumer guide that you see listed on the slide that's available for free download on our website at Justice and Aging. We've designed these materials to specifically call out these false statements. So we'll be having this discussion during this session, and you'll see that I'll flag a false statement. And it's meant to educate you, to prime you a little bit. So in your own life, in your own work, when you hear a false statement like that, you'll know immediately that's wrong. You'll be able to recognize it. And when you hear it, then you need to understand that it's not true, and as we'll discuss, you'll instead know, in addition rather, know the law, that's the truths, if you will, what should happen, what's obligated to happen under the law, and you'll also have some strategies to deal with it. So, but I'll point you, I'll recommend, if I can, our own guide, 25 common nursing home problems and how to resolve them, available for free at justiceandaging.org. So we'll begin this series of problems, and as I mentioned, they're organized by falsehood and truth. This is the false thing that you'll hear. This is the truth thing. This is what's actually required by law. The false statement applies in this case when a person first enters a nursing facility and the family member is told, oh, we're assuming it's a daughter in this case, you're going to have to sign the admission agreement as a responsible party. Don't worry about it, no big deal. You're just a contact person. That is almost certainly a misstatement, a lie, of falsehood. What's almost certainly happening in those situations is the facility is trying to get the adult child, in this case, to become financially responsible, and that is inappropriate because there's a federal law that prohibits a nursing facility from obtaining a third-party guarantee of payment. The only person that should be liable under the admission agreement is the resident, not a third party. Can't be required or requested. One level of detail here, this does not prevent say the daughter, for example, from acting as an agent for the resident. That is okay. As we all know, there's a lot of residents in nursing facilities who, because of dementia or some other reason, aren't in a position to handle their own affairs. And so it is completely appropriate for an adult daughter, son, grandchild, whomever, to act as the residence agent, but that's only to obligate the resident to financial responsibility. It doesn't make the agent responsible. Regardless, there are some facilities that still try to collect against family members. You'll see lawsuits against the family member, trying to make the family member responsible. If you're in those situations, of course, you should consult with a lawyer. In general, if they're defended, those suits should fail unless the family member was really acting inappropriately and, for example, trying to loot the resident's money for the family member's own benefit. A lot of the problems here can be avoided if the admission agreement provisions, the bad provisions, aren't signed at the front end. So it is recommended that, of course, you look at the admission agreement before you sign it, before the resident signs it, before the agent signs it. Be aware of some of the improper provisions, like a financial guarantee that might be in the admission agreement, and then delete them, right? Revise them, X out the improper language, and then explain to the nursing facility why it is inappropriate. Now, I recognize that there's some risk that that'll complicate or prevent the admission. In a lot of cases, that's not a problem. If the resident's already been admitted to the facility, there's no risk. But in any case, as an advocate, I would recommend that people push back and never sign something that you think is dangerous because of your unwillingness to create a disturbance, if you will, or to complicate things. I think people's inclination sometimes is to think, I don't want to create any problem here. It'll probably never matter anyway. And it might not, but I'll tell you, it may well. And every year there are scads of published cases on these sort of situations where the person signed something, maybe at the time they didn't pay any attention, they just signed it, or they hoped it wouldn't matter, who knows what, but it ended up mattering. And when you tell the judge down the road, oh, I didn't really want to sign it, or I didn't think it would matter, oftentimes the judge's response is, well, that's too bad. You saw it, it was in front of you. You could have read it, and whether you read it or not, you signed it, and you're going to be held responsible for those provisions. So people really need to push back in these situations and protect themselves. A second admission-related provision deals with arbitration agreements in admissions. These are provisions of the admission agreement that state that any disputes down the road will be sent to a third-party arbitrator rather than a state court, for example. These provisions also are not recommended. There's no reason why a resident, when you're entering into a nursing facility, should make some sort of blind promise to send all future disputes, whatever they might be, to arbitration. It's not a good option for residents. The arbitrators may have a little bit of a leaning towards the nursing facility because they may have a lot of repeat business with the nursing facility. So it may be in the interest of the arbitrator to lean a little bit towards the nursing facility's direction. A lot of times the arbitrator is going to have less empathy than the jury. A lot of these cases, at least the ones that end up in litigation, tend to be damages cases against nursing facilities for poor care, and a jury may be sympathetic to a resident's point of view, but an arbitrator potentially less so. And then thirdly, a lot of the arbitration agreements may have provisions that disadvantage the resident in one way or another, relating to experts, relating to discovery processes. There's related to damages that are available. It's just generally not in a consumer's interest to sign an arbitration agreement. And the best argument, if there were a facility attorney on this call right now, what he or she would probably say is, arbitration is more efficient. It's quicker potentially. Court processes can be so convoluted, and this is more streamlined. But in response to that, I and others would say, okay, fine. But that's only true if a person actually chooses arbitration. If a resident has a dispute, let's say it's a personal injury dispute, and at that point, the resident decides it's in his or her best interest to choose arbitration. Just, I'm not sure that'd be the case, but just assume that. That's fine. That would be an eyes wide open decision made by a consumer. But that's not what happens in these situations. No one, when they're signing an admission agreement, coming out of a hospital, trying to figure out what's going on, entering a nursing facility, no one on the consumer side is even thinking about arbitration and future dispute resolution. And it's a completely inappropriate way of binding something to a particular process that'll probably be not in their best interests. Just like in the financial guarantee situation, the easiest way to deal with this is not to sign the agreements at the front end. If you look at the arbitration agreements, oftentimes they claim that they're voluntary. You look at them and it goes through some recitations saying that the resident or the residence agent doesn't have to agree to arbitration. And if that's the case, you just point out that out to the nursing facility and say, look, it says right here that I don't have to sign it as a condition of admission, so I choose not to sign it. And also, in any case, if the resident's already admitted, the resident or the resident's representative has a lot of discretion just to say, no, I choose not to sign anything. This is an inappropriate provision, and I'm not going to agree to it. If the arbitration agreement has already been signed, things are not necessarily lost. There are defenses. In any situation like this, you'd be consulting with an attorney, and the attorney would be thinking about it, and you'd develop the facts. But just to flag them quickly here, defenses include that the resident lacked legal capacity when he or she signed the agreement. Maybe the family member didn't have authority, an adult child, for example, who signed it, but without authority as a power of attorney or something else. And also potentially the arbitration agreement might be unconscionable under state law. And that finding that the agreement is unconscionable generally requires proof that the agreement was unfair in two ways: that the process was unfair, that there was an unequal bargaining power between the facility and the resident, and also that it was unfair as far as the terms of the agreement go, that the agreement was written in such a way that it was grossly unfair in favor of the nursing facility. So moving from the admission agreement now to this stay in the facility, we'll talk about the care that's provided. A common falsehood is this idea that the care in the facility, what happens during the day, is driven by the nursing facility. The medical professionals are just going to decide, right? These are the people with the nursing degrees and whatnot. And so who is the resident to push back against that? In fact, the resident is entirely in the right position to push back. And under the federal law, the resident and the family are meant to be the driving forces in developing a care plan. There has to be this comprehensive person-centered, that's an important term, person-centered care plan for each resident. Now, just note here, these references here to the federal regulations, Title 42, Code of Federal Regulations section. I don't expect people on this call necessarily to be flipping through the federal regulations, but I've listed the citations here if you're looking for the authority at some subsequent time. So person-centered is a very important concept. It's been enshrined in the federal regs since late 2016, and it means exactly what the term suggests, that it's focused on the resident, right? It's the resident's interests that should be paramount. It shouldn't be about what's easier or typical for the facility. It should be about what makes the most sense for the resident in his or her life. And under the regulations, the resident has this right to receive services with, another key term here in the third line, reasonable accommodation of residents' needs and preferences. So if a resident says that I want this, that, or the other thing, it can, so this kind of change to my schedule or this sort of assistance, the facility can't just out of hand refuse that. They have to consider it. And if it's a reasonable accommodation to what the facility does, the facility has to accommodate whatever the resident wants. This care plan is done soon after, the initial care plan is done soon after admission. There's a first an assessment, then this care plan within a week after that by an interdisciplinary team that includes the resident, the resident's representative, and some other healthcare professionals as listed here, the physician, a nurse with responsibility, the nurse aide, and then some other folks on the facility staff and others as chosen by the resident. So the concept here is holistic, really strong, right? You've got this care planning process. It starts with the assessment that reports what the resident can do, needs help with, resident's healthcare needs, and then you sit down with the resident's representative, and the healthcare professionals and figure out what should be done for that particular resident. In practice, on paper, great, just terrific. In practice, there's a lot to be done because in most cases, unfortunately, the care planning process falls far short of what the regulations call out. So all of us need to do better. We need to push more. We need to educate. If facilities do it badly, we need to push back against them. Maybe assist residents to give them a little bit of support so they're prepared to participate in the care planning process, so they're not just blindsided. Sometimes these care planning meetings in the facility are presented by the facility as no big deal. Send a notice to the resident. the residents' representative said, "Oh, you come by. We got 15 minutes set aside for you next Wednesday at 10:30 to talk about a care plan." And the facility's assumption is they'll just push a button, the computer will spit out a care plan based on the assessment, and that'll be it. But that is not how it should go down. And so to make sure that the care plan really is person-centered, it's best that the resident give it some advanced thought and think about it. What do I want, right? What would be helpful to me? And with some reasonable sense of entitlement. I think oftentimes residents are just very reticent to ask for anything, and that's not their, with all due respect, and I get it's easy for me. I'm a lawyer sitting in my office talking about these things as opposed to sleeping in a nursing facility tonight. But this is the right advice for people in nursing facilities. They should think, I'm paying, or somebody on my behalf is paying, how much a month? 6,000, 8,000, 10,000, a lot of money. And for that kind of money, I should get something. And what do I want? And think broadly. This scheduling thing, I want this to change, whatever it is, and then ask for it. There's people need to think broadly, and whether it be scheduling or services or getting out of the facility or whatever it is, to make the request and then expect the facility to reasonably accommodate that request. Related to that is the activity discussion. The misstatement here is that all we can do is bingo or something else, whatever it. I don't want to mean to pick on bingo necessarily. It's stereotypical in nursing facilities, but television watching or whatever else, some kind of limited type of activities, limited and not individualized. And the facility actually under the regulations has an obligation to go much beyond that and think about what individual residents would want. This is the regulatory language here, and in these activities are, as you'll see in the language, both group activities and individual and independent activities, and which should, to the extent desired by the resident, involve the quote-unquote outside community. It depends on the resident's health condition and preferences, but to get outside the four walls of the facility, for example, entirely appropriate request. And also the surveyor's guidelines that go beyond the regulation include some suggestions for activities for certain populations. You can see the list here: folks with dementia, who are withdrawn or who have delusions. Just mentioned here in the surveyor's guidelines, it's Appendix PP, the letter P twice, to the Medicaid State Operations Manual. So it's the surveyor's guidelines is a 600 or 700 page document that provides a tremendous amount of detail and fills in some of the gaps of the regulations with some really good language. And this is one example of that. But I think you get the point here that it is definitely not a matter in nursing facilities in just playing bingo or watching TV or something. Again, nothing wrong with those, but there is an expectation, a requirement, even for the facility to go far beyond that and to develop activities that are specifically targeted to what individual residents may prefer and want. Another related item dealing with choice and accommodation, the facility's response regarding menu requests might be, well, look, this isn't a restaurant here. This is a nursing facility. Here's our menu. You get what you get, and because that's the way we do it here. Actually, under the regulation, the facility has an obligation to do more than that and to try to meet residents' preferences. Not as far as you'll see, like it's not completely a la carte. It's not completely a restaurant situation, but it goes a little bit in that direction. There's a regulatory obligation here to make reasonable efforts to meet religious, cultural, and ethnic needs, and to respond to requests from individual residents. And then this is the surveyor's guidelines language, making reasonable efforts, good faith efforts to develop a menu. Just like the service plan, the message here to residents is, and to resident groups is, to think about what you want, right? Make a list, whether, what on food items or types of food, depending on what it is, and write it up and think about it and specifically make the request, because a facility does have an obligation to try, specifically when there's a explicit request for some sort of modification to the food that's offered. A false statement related to leaving the nursing facility. The idea should not be that once someone enters a nursing facility, they're never going to leave. That is inappropriate. The federal law and the federal regulations make it clear that facilities oftentimes should be set up to assist people in moving on to other settings. And despite what you see in this misstatement here on the left, it actually is the facility's job to assist people to get out. We talked about care planning earlier. Remember the interdisciplinary team and whatnot. The care plan contents have to include services and goals within the facility, but also they have to include discharge related items as well. Whether the resident wants to leave, or how the resident wants to leave, where the resident wants to go, so that the resident of the facility can try to develop those things and make it more likely that the resident will be able to move on to a different setting. The default here is that the resident would have a discharge plan. Right? So that has to be the initial idea, that the resident would have a discharge plan, how to leave the facility. If that's not true, it needs to be clearly documented how that opposite decision was made. Who was it that decided that the resident isn't going to be leaving? And if there is a discharge plan, it needs to be reasonably comprehensive and consider important things like the assistance that the resident may need if he or she is back home, for example, and whatever resources the facility might have provided to assist the resident in getting back outside of the facility to a home or apartment, for example. This next falsehood relates to one of our core principles, the second principle. You'll remember I said that there shouldn't be any discrimination based on reimbursement sources, and this is an example of that. A facility might say, well, we can't provide one-on-one assistance, for example. You hear all that all the time during meals, or helping people getting in and out of bed, or moving down the hallway, or whatever it is. That is not true. That under Medicaid, like under any reimbursement source, the facility has to provide the care that's necessary to get the resident the highest practical level of functioning. There should not be any discrimination based on reimbursement source. This is the regulatory language. The facility has to have identical policies and practices regarding transfer, discharge, and the provision of services. So shouldn't be any poor treatment of Medicaid eligible people. Now, I say that knowing that in practice out there, you may hear a lot of times from facilities that Medicaid eligibility prevents them from doing this, that, or the other thing. Hear statements like, well, Mr. Carlson, you know that we lose $4.19 every day on every Medicaid resident, for example, whatever the excuse is. When you hear things like that, you don't want to accept it. You want to push back. And this is the simplest reason why. The facility has promised to provide equivalent care for Medicaid eligible people. They didn't have to certify themselves for Medicaid. No one's forcing them to do it. They chose to do it. And when the facility chose to accept Medicaid reimbursement, it promised the state of New Jersey in this case, and the federal government, that the facility would provide the legally required level of services to all Medicaid eligible people. So it's really inappropriate for the facility to make that promise to the federal and the state government, to take the money, they're taking the money, and then turning around to the resident and saying to the resident, well, yeah, we took the money and we promised that we provide equivalent care, but we're not going to do it because we don't think it was enough money. Some of us work in a nonprofit field. Maybe we think we should get paid more than we do, but we still got to do our job, right? All of us have to do our jobs regardless of how much money we're getting paid. We've got a duty of care, and we got to live up to that. And regardless of what our salary might be or what our reimbursement might be, and the same thing here is true for nursing facilities. They've made the promise. If they don't want Medicaid certification, they should be straight up and turn it down at the state level and at the federal level. But what they can't do is accept the money, right? Cash the checks, and then deny services or deny a certain level of services to residents. Just a quick discussion about visitation here, and it was mentioned, visitation has obviously been a huge issue over the last couple of years, dealing with COVID quarantines and whatnot. This particular discussion is not limited to COVID. It's focused more on general visitation principles. The falsehood is the facility saying that people can only visit at certain times, noon, 8 in this example. That is actually not true. A resident has a right to accept the visitor at any time, 24 hours a day. It's the resident call. If the resident wants to accept a visit at midnight, that's fine. But it's the resident's decision. The resident has a right to immediate access by anybody, really, by family members or non-family members. The regs say that non-family visitation is subject to reasonable clinical and safety restrictions, which suggests that there wouldn't be any limitations on family visits, since that just applies to non-family visits. In any case, the clinical or safety restrictions are really narrow. This is a list in the surveyor's guidelines. So maybe somebody, again, a non-family member, would have limited visitation related to infection prevention and control, if there's a suspicion of abuse, theft, the person's drunk or disruptive. Anyway, very narrow category. The short message here is that there shouldn't be any limitations based on visiting hours. There shouldn't be any visiting hours, rather, and that in general, it's the resident's decision whether or not to accept a visitor, and the facility can't get in the middle of the resident's decision to visit with somebody. Talk here about a couple falsehoods related to physical restraints and then Medicaid chemical restraints, i.e. inappropriate medications. First, the physical restraints. The falsehood here is the facility saying, well, your dad may fall down, and so we're going to have to tie him into a chair. The law says that physical restraints can't be used for a facility's convenience. In fact, they shouldn't be. I suppose they'd only be used for safety concerns. In general, this level of care these days is very negative towards use of restraints. I think the consensus, and I'm not a clinician, but from what I understand and see, that a lot of providers really take pride in providing care without restraints, without any kind of physical restraints. You avoid a few things. You avoid the physical injury that might occur either because somebody's stuck in the same place for long periods of time, or because they may asphyxiate themselves trying to escape. And you also avoid just a general sense of humiliation and personal discomfort caused from being restricted physically from moving in some way or another. the most important provision to mention and to remember here is the idea that restraints, like medication, can only be imposed with consent. So it's not something that a nursing facility or a physician can just do. It's something that has to be accepted by the resident or the resident's representative. So when you're in an advocacy situation and you're the resident or someone advocating on the resident's behalf, you shouldn't have to get into a discussion about whether something's used for discipline or convenience or not. You should just be able to say, on behalf of the resident, I choose or reject these restraints, because that's a decision that's binding regardless of what particularly the decision to refuse restraints is binding regardless of what the physician or a facility might say. And then the related issue is the chemical restraints, use of inappropriate medication. The facility might say that a certain type of medication is necessary to sedate the resident. Under the law, the medication can only be used to address a diagnosed illness. A lot of the conversation about this issue relates to the psychotropics, the antipsychotics and antidepressants, the mood altering, the sedative type of medications. The regulations specify that this only be used to treat specific conditions, and there should be an effort to keep the use as limited as possible. But it's an ongoing problem that if you look at the rates of this, that there continue to be a significant increase in the use of antipsychotics. And also, even though those antipsychotics are not generally approved for use on older people, a lot of times they're used with black box warnings that say that this particular kind of antipsychotic is not approved for use by older individuals. So you see the use, and also you've seen a very suspicious increase in the number of psychiatric diagnoses. So the evidence suggests that in some cases, physicians and nursing facilities, in order to get around the law, have created diagnoses of psychosis in order to justify use of these antipsychotic medications. So an ongoing problem. It's one of the things that was identified in the president's recent initiative on nursing facility quality as part of an effort to reduce the use of antipsychotics in nursing facilities. But for the purposes of this conversation, focusing on the individual resident, just as is true for the physical restraints, the important thing for the resident's representative to know is that consent is required. Right? These medications can't be administered without the consent. So if you see that it's being administered, what the resident, or more likely the resident's representative, needs to do is to make it clear that the facility and the physician do not have consent to administer that particular medication. There's also some falsehoods related to Medicare, and as we'll see, that has some effect on some eviction discussions as well. The Medicare coverage falsehood here is the falsehood that the facility just has sole discretion to determine Medicare reimbursement. That is not true, because the resident can require the facility to bill Medicare. There's a couple different ways this plays out. The version that I'm going to discuss here deals with straight Medicare, when a person has fee-for-service Medicare, and I'll talk about the notice requirements. There's also a version of Medicare, the Medicare Advantage, where Medicare is provided through a managed care plan. Let me just make a general statement about both of these, either fee-for-service or Medicare Advantage, that is the managed care situation. Under either situation, it is not the sole discretion of the nursing facility or the managed care plan. Under both of those situations, the resident has some appeal rights to push back against these decisions and to argue that he or she is entitled to Medicare coverage of his or her nursing facility care. So, as is oftentimes the case in this presentation, right? Rule number one is don't take it lying down, push back, appeal, reject, right? Advocate. And so that's the rule number one related to Medicare. In Medicare Advantage, there's a certain appeal process that's carried out first through the managed care plan, and then there's a second level of appeal to an outside decision maker. In fee for service, there's initially a notice from the nursing facility that says that the nursing facility doesn't believe that the care that's needed is going to meet Medicare coverage requirements. And then this notice that the resident will get has to list the type of care and some reasons that Medicare might not pay. And then it's given three choices. Either one choice is that a choice to bill Medicare for the care. Second choice is to get the care but not bill Medicare. And then the third choice is not to get the care. If the person believes that they qualify for Medicare, then of course they would check the first box. There's an appeal process that's submitted. And if for some reason the facility doesn't do this notice appropriately, the resident has an argument that the resident is not financially responsible. It gets a little convoluted and goes through Medicare appeal processes, but I wanted to flag it here, and that's why there's a reference to Chapter 30 in the claims processing manual. So let me just wrap up the Medicare discussion because it can be a very long discussion. I wanted to cover it, but I don't want to spend 20 minutes on it. It's important. Medicare coverage can be important. You shouldn't expect too much because Medicare by definition is a bit limited. It's only a post-acute benefit. In general, it's after a 3-day hospitalization, although that's been waived during COVID. But in general, it requires a 3-day hospitalization. And then this is the biggest limitation, a skilled service, generally a skilled therapy that stems from the hospitalization. So physical therapy, occupational therapy, speech therapy. The short of it is Medicare doesn't pay for just quote unquote routine nursing facility care, but instead is going to pay only for post-acute care under certain circumstances. But I want to draw the right line here. I don't want to say that everybody gets Medicare, but they don't. But what I can say is more people should get more Medicare coverage than they do, and that's why you should be conscious of the rules, and also you should be feel completely comfortable in following the appeal processes, either in fee-for-service Medicare or in Medicare Advantage. A related Medicare issue, let's assume that the person got Medicare initially, coverage for a couple of weeks, and then is told, oh, Medicare won't pay anymore because you've been receiving physical therapy, but you've plateaued. You're not making any progress. That is an inappropriate rule. Improvement is not required. You hear this all the time. It's been going on for decades. So when you hear something about plateauing or failing to progress, you should push back. A couple reasons why. First of all, it shouldn't all be about reimbursement source. Remember, you should get the care that you need regardless of how your care is reimbursed. And under the regulations, specialized rehabilitation services, right? Rehab, should be provided to any resident who needs them regardless of reimbursement source. So even if Medicare's not paying, for example. And then when you get to the Medicare standard, the Medicare coverage requirements do not require improvement. That's this regulation in this gold language here in the middle of the slide. This is regulatory language that's been effective for decades. It says the restoration potential is not the deciding factor in determining whether skilled services are needed, right? So it doesn't matter if you're not progressing. The standard needs to be, is this rehabilitation service appropriate, right? Is it, if it's futile, then no. But if it's medically advisable, then it's appropriate without any particular defining about progress. How it plays out in practice, oftentimes, as I've seen it, is in nursing facilities or managed care plans are just getting pressure to not pay. There's maybe in the nursing facilities getting pressure from the Medicare contractor, and so they get to be too squeamish, too stingy in authorizing services, and too quick to just decide that somebody isn't progressing anymore. Say somebody's had a stroke, for example, and they're doing some rehab and they're trying to walk further without assistance, and then for a couple days, maybe they'll only be able to go 50 feet with limited assistance, but it's still 50 feet over several days in a row. And then too frequently you see situations where there's just a determination, oh, no progress, plateauing, that's it. It's wrong based on Medicare standards for the reasons that we just talked about. And it's just wrong clinically as well. I'm not a clinician, but rehab takes time, right? You don't make progress every single day. It doesn't work like that. Maybe you are at the same level more or less for a couple of days, or maybe a week or two, I don't know, but it's a process. And so that it's important that these Medicare decisions reflect that. And then, so wrapping this up, this has been the law forever. It's been a problem forever that, you know, there's been these misstatements and misapplications of the law. There was recent litigation against the federal government, Jimmo versus Sebelius, brought by our friends at the Center for Medicare Advocacy and some legal aid colleagues in Vermont, I believe. And that reestablished, emphasizes pre-existing regulatory right. So if you're looking for authority on this, saying that progress isn't required and that plateauing isn't a problem, take a look at these resources that relate to the successful Jimmo versus Sebelius case against the federal government. This CMS has a Jimmo website. I've listed the URL here, and then there's a fact sheet and some changes to the program manual. And I commend those to you. They're really strong authority to show that Medicare should be provided regardless of supposed concerns with plateauing or lack of progress. The additional Medicare related falsehood here is this falsehood that the person has to leave their so-called Medicare bed when the Medicare payment has ended. That is not true. This idea of a Medicare bed is not quite right, because a Medicare bed may be certified for Medicare reimbursed people, but it's not limited to Medicare reimbursed people generally. So the fact that somebody's in a Medicare bed doesn't prevent them from staying in that same room, even though their reimbursement is switched to paying out of pocket, for example, or Medicaid. In general, it could be a little more complicated than that, but in general, that's the case. And there is, under the federal regulation listed here, a right to refuse a transfer within a facility if the purpose is to move the resident out of a Medicare certified room or solely for the convenience of staff. So you shouldn't have these situations where the resident's being forced to move just immediately because their Medicare is ended. And it's most important, really, when the resident is being told by the facility, not just that they have to move from one room to another, but when they have to leave the facility entirely. And you'll see that as well. there are these facilities that claim a specialization in Medicare. It's a business practice where they try to get as many Medicare eligible people as they can because that's the highest reimbursement rate. Unfortunately, that strategy often leads them to just getting rid of Medicare people as soon as those people fall off of Medicare. As I mentioned, Medicare reimbursement tends to just last for a month or so, and by law doesn't last longer than 100 days, although most people don't go anywhere near to 100 days. So you shouldn't have this situation where people are just pushed out when their Medicare ends. They should absolutely, if they want to, be able, first of all, they can appeal the loss of Medicare under the procedures that we talked about. And then in addition, regardless of Medicare, they should have the right to stay under a different reimbursement source if they want to stay under private pay, for example, or under Medicaid reimbursement. Which brings us then to discussions about evictions. The facility's false statement here is that the resident has to leave because he or she is a quote unquote difficult resident. In fact, residents can be forced to leave only for one of 6 limited reasons. And these are the 6. The resident, the first 2 deal with level of care. The resident needs a higher level of care or doesn't need nursing facility care. Is it a lower level of care actually? Number 3 and 4, dealing with safety or health. Supposedly the resident's presence in the facility endangers other people's safety or health. Number 5, the resident has failed to pay. And number 6, the facility is going out of business. So those are the only reasons. My take on this, based on what I've seen over these many years, is that the facilities are usually wrong here. Almost always they don't have grounds, but for non-payment. Clearly, if resident has to pay, and if you do get these situations where people just refuse to pay and there's no right to free nursing facility care. But a lot of these other transfers and discharges are situations under usually number 1, 3, or 4. It's a resident who's probably Medicaid eligible and then who's difficult in some way. And the facility says, well, this person needs a higher level of care, or claims that this person's presence endangers safety or health of others. And I think in practice, that's almost always untrue. The resident may be a little bit difficult. The resident may need some particular extra assistance, but so what? It's still a resident who's entirely appropriate for a nursing facility, right? That's the level that he or she, as far as residential facilities are concerned, is appropriate for. Not a hospital, not a locked psychiatric facility, a nursing facility. And so in that situation, the residents need to contest these eviction notices and to take it to an appeal. As I mentioned, quote unquote difficulty is not endangerment. And what the facility should do rather than move to eviction is go back and look at that care planning process that we talked about. Think about what to do, how to deal with the problem rather than just shuttling the person off to some other facility. Ideally, the facility will sit down, convene a care plan meeting, right? Bring together the resident's representative, the physician, the staff of the facility, and figure out the best way to address the situation. There are some transfer discharge initiatives based on non-payment related to Medicaid approval. The facility might say, let's assume that somebody's been paying out of pocket, but they run out of money, and they're waiting for their Medicaid approval. And the facility says, "Oh, look, we can't wait. We've already been waiting 2 months, and it's not our fault that the county's taking so long to figure this out. You're going to have to leave." That is in fact not true, because under the law, the facility has to wait for the Medicaid decision. This is the regulatory language. You see that non-payment only applies if the resident does not submit the necessary paperwork for third-party payment. So if the resident has submitted the paperwork, right, if it's pending with the third party, in this case, the Medicaid office, that's considered payment, and the facility needs to wait until that process concludes before making any eviction request based on non-payment. Related to that, an eviction effort to force someone out after Medicare payment ends. We talked a couple minutes ago about Medicare payment and how it tends to be limited to just a few weeks. You will see this situation, as I mentioned, where a facility that's trying to focus on Medicare eligible people, and sometimes these facilities will say, we're just a rehab facility, or we don't provide custodial care. What they're really saying inappropriately is we're trying to just limit our facility to Medicare people, and when their Medicare payment ends, we're going to try to send them on their way. So it is a falsehood that people have to leave the facility. If they really want to evict somebody, they have to give notice and wait for a hearing, and they'd have to have grounds. And in these situations, in most cases, if the person wants to stay, the facility wouldn't have grounds, because even when the Medicare ended, the resident would be able to pay out of pocket or pay via Medicaid, as the case may be. In any case, the facility, rather, on all these transfer discharges, has to give written notice. It generally has to be 30 days prior to the date of proposed transfer discharge, and then it has to include these particular items of importance. The reason why you're being forced out, supposedly endangering other people's safety or health, or non-payment, or facility going out of business, whatever it is. Effective date, whatever that is, probably at least 30 days in the future. Your new residence, some other facility or someplace else, the facility has an obligation to identify that. The appeal rights you have, because you do have a right to get an administrative hearing in front of a hearing officer for the state, and then contact info for the ombudsman or other long-term or other relevant advocacy organizations, sometimes the protection and advocacy organization for the state. There shouldn't be, as I mentioned, these situations where people are being tossed when their Medicare is ending. They should instead be able to convert from Medicare to another force of payment if they intend to stay in the facility. As I mentioned, it's not the facility's choice. The resident has a right to a ruling by an administrative law judge, and you can't have a transfer discharge while an appeal is pending. That's common sense. It wouldn't make any sense to have the hearing officer be thinking about this, a facility just going off and evicting somebody in the meantime. The facility has to wait until the process runs its course. The number one rule is don't move out. I think I can, probably this would be confirmed by any ombudsman program rep that you might talk to. You just run into a lot of people who panic and leave, and then they might say afterwards, oh, I changed my mind, or what can you do for me? And the answer that I usually give them is it's too late. You left. If you leave out of your own volition, you just can't get yourself back in, and you've lost the case. And again, no disrespect to people. I get it. I understand. It's easier for me as a lawyer to say this sort of stuff. I am empathetic to people's situation, but if I'm counseling them, when I'm telling them it is not in your best interest to just leave like that, you have appeal rights. You're better off exercising those appeal rights. It's in your interest to. It's relatively easy. You don't have to pay a lawyer necessarily. It'd be great to have a lawyer. If you don't, you're not necessarily lost. It's a relatively informal process, and residents should win most of these, because in most cases, if it is about the resident supposedly endangering somebody or needing a higher level of care, in most cases that's not true. They still belong at a nursing facility level. And you can tell that oftentimes because the facility on their transfer discharge notice might say, oh, we're proposing to transfer this resident to nursing facility B, and the argument then obviously is if nursing facility B can care for this person, there's no reason nursing facility A couldn't have figured it out if they did the care planning that they should have done. Another advocacy tip, you don't want to let the facility demonize the resident. I've done a lot of these hearings, and you'll get these situations where the resident is difficult, is quote unquote acted out, whatever it is, been calling out at night, he has dementia, is moaning and talking and whatnot. And you get situations where the facility brings in the staff and all the staff is lined up to say, oh, this person, this resident did this and did that and didn't follow instructions or whatever it is. And you don't want the conversation to go in that direction because the resident has dementia, right? The resident's living in a nursing facility for a reason. And so it's unfair for the facility to act like they just have, like it's some kind of finishing school and the residents have to follow all these rules perfectly. It's a nursing facility and it's the facility's obligation to figure out how to deal, for example, with people with dementia. So you don't want to get the conversation going in the blame the resident direction. You will, I don't want this to sound badly, but you want it to go more in a blame the facility direction. And I say that a little bit facetiously, but to make a point, it is the facility's responsibility, right? They're the professionals. They're the people who are being paid $6,000, $8,000, $10,000 a month to provide care for residents with dementia. They're the people with the medical degrees. They're the people who need to be convening these care planning meetings and figuring it out. And so if the facility just immediately decided, oh, we have a problem here, we're going to evict this person, it is the facility's fault. They didn't do their job. And if they failed to consult with the physician or to convene a care planning meeting, and if they just immediately went off and tried to evict this person, it is the facility's fault to a great extent, and that needs to be pointed out. You will get some of these evictions that are essentially lockouts, where the facility takes action against the person by refusing to let them back from a hospitalization, and it's harder for the resident. It's inappropriate, but it puts the resident in a difficult position because he or she is in the hospital and needs to figure out a way to how to get back to the nursing facility. The right to get back on paper is pretty strong. I'm not a New Jersey expert, but I did a tiny bit of research today. Someone can correct me if I'm wrong. I think there's 10-day bed holds in New Jersey. So a person has a right to, if in a hospital, to hold the bed for 10 days. If it's private pay, the individual has to pay for those days. If it's Medicaid reimbursed, the Medicaid program is going to have to pay. In addition, on top of these rights, there is a right under federal law for the resident to get back to the next available room, the next available bed, regardless of the length of the stay, as long as the person is coming back under Medicare or Medicaid. So preferably the previous room, but if that's not available, the next available one. So even if, for example, the person was in the hospital for 11 days, for example, or 15 days, or 51 days, he or she would have the right to get back into the nursing facility in the next available bed. And let me just finish the conversation about how to make that happen here. That it's harder from an advocacy perspective. On these eviction cases in general, as I discussed, the rule is just don't move out. But if you're already out, you got to figure out a way to get yourself back in. You may request a hearing, that may be useful, but it depends on how quickly the hearing officer will rule and whether you're still going to be allowed to remain in the hospital that time. Sometimes you want to act as an advocate more quickly than that. And so either going to the licensing and certification office and the inspectors essentially, and to make a complaint saying that these people are trying to evade the transfer discharge rules, and make a complaint and really push them to act immediately to get the person back into the nursing facility as soon as possible, or request a court order, some sort of temporary restraining order, an emergency order to force the facility to let the resident return if the facility is refusing to let the person return. And I've sought those and gotten them, and the judges understand that it is really a lockout type of situation, and the facility has taken advantage of the hospitalization to put the resident in a really precarious position. Just make a quick plug for some of the materials that we have related to transfer discharge. I already mentioned the Justice and Aging 25 Common Nursing Home Problems Guide. That's on our website. On the same nursing facility page, there's a Justice and Aging page devoted to nursing facility issues. There's a link to an eviction defense toolkit that might be really useful for folks, that includes some one-pagers related to common transfer discharge eviction issues. So I recommend that to you, and also has administrative hearing template documents. So if people find themselves in administrative hearing on a you are too difficult type of case, for example, we've developed some template documents that can be used, modified obviously. You'll have to change the names and add in some facts, but you can use the template document to develop the legal discussion that you need in a case like that. And then thirdly, and specifically relevant to this issue, some legal documents that can be used as a template when people are seeking a temporary restraining order to force the nursing facility to allow the person to return to the facility from a hospitalization. Yeah. The final exam. I should have just said final review. Nobody's taking scores here. So final review. The two core principles. Think, what are they? Number one, the care that's needed to get to the resident the highest practical level of functioning. Right? Now, they got to do the best they can. That's the short of it. And then number two, no discrimination against Medicaid eligible residents. So overall, the facility needs to do the best they can do, and it shouldn't be limited by a particular type of reimbursement source. Okay, this one I think you could have a good chance of getting right. The first rule of avoiding eviction, we were just talking about this. Right? Don't move out. And if you're counseling people, you just need to give them the confidence to hang in there, because if they do that, they're probably going to do really well, and that's what's necessary. They're right on the law. They almost certainly are right on the law. In a vast majority of instances, they're right on the law. They just have to stay in there and put the onus back on the nursing facility. And then the final thought is thank you. You do really great and important work, which it's tremendously important. And just related to those other issues, those of you who are working with nursing facility residents or who are working in this field, you can do so much good by just empathizing with people, giving them some support, giving them this information. I know that people, when they're in the facility, when they're in this situation, they feel under siege a bit. They feel isolated. They feel like the nursing facility's got all this power. They're just overwhelmed by the situation. I get all that. But if they can just hang in there and push back, they have some options. And so for all of you today who are interested in this issue as part of your own family, or just, some of the advocacy work that you do, or your job, or any combination of those, these issues don't get nearly enough attention. There's so many people who benefit from the work that you do, and I thank you very much for doing it. And so with that, I'll turn the program back over. We'll see if we have any questions and go from there.
We definitely do. Thank you so much, Eric. That's such great information. And we have a wide variety of people in our audience. We have family members. We have people who work in long-term care facilities who face those challenges that you were just talking about. and advocates. So I'm just going to start kind of with the first questions. When you were talking about financial responsibility, the question was, can a spouse be held responsible for nursing home charges? It's from Christine.
I'll say maybe. That's not a matter of the nursing facility admission agreement. That's just a matter of state law related to when one spouse may be, and under what circumstances is liable for the debts of the others. So I don't. So that I know less there. I think it's a matter of state law. It's not about the admission agreement. It shouldn't be about the admission agreement. It shouldn't. But regardless of the admission agreement, it may be that that one spouse is obligated for the debts of the other, but I can't speak to that from 3,000 miles away.
Right, and then there are Medicaid rules and things like that on community spouse and things like that, but those are national. But so for those of you that we don't get or we can't answer your question, we'll try to find the answer and email you back because we have all of your emails. GF Harris talked about that, said that there's specifically a home in Englewood that's only allowing visits Monday to Friday. That is, I would encourage you to please call our office. When it comes to visitation issues, the federal guidance is very clear. They cannot restrict visitations in that way. Please contact the Ombudsman's office and we'll work that through for you. That's just a clear violation, even with COVID restrictions. If the resident or representative doesn't accept that an antipsychotic be administered, can the facility say that taking the medication is a condition of continued care at that facility? And if the resident or their representative refuse the medication, must they leave the facility?
No. No, I mean, think about that. You can't stay here unless you take this medication that you don't want to take. No way. For the reasons that we discussed.
Right. So this is regarding the resident has a right to immediate access to visits. Can an assisted living that has a few Medicaid beds use the infection-related restrictions to limit? Again, I would encourage you, they can't. It really is on a case-by-case basis. There are some examples where there's a high community spread where they may be able to put some additional visitation restrictions in, but we really are able to kind of work through those things. Sometimes the local Department of Health goes further than what the federal requirements are and what the state of New Jersey requirements are. So we have to, and Laurie's nodding her head because we've dealt with this a lot over the last couple of years. And again, I would encourage you to contact our office on that because generally, no, they can't do that.
Can I make one other point? I think the question was talking about an assisted living facility, right? So
yes,
the one thing everything I said here today relates to nursing facilities.
yes.
Right? This was a nursing facility presentation, 100%. So we did not talk about assisted living here at all. And the law is going to be completely different for assisted living, completely different.
That's true. Unfortunately, because there are far fewer protections for assisted living than there are for nursing home residents. This person said, I thought the Jimmo versus Sebelius ruling addressed the plateauing issue regarding physical therapy, occupational therapy, I'm not sure what ST is, and SNFs, and that SNFs can't use this as an excuse. Did I understand that correctly? You did. I mean, that's what an issue where they throw people into restorative therapy and don't do the rigorous physical therapy.
Yeah, I think we're saying the same. I think I said the same thing that the questioner just said, that you're right, that Jimmo deals with rehab services reimbursed under Medicare in nursing facilities and also on an outpatient basis for that matter as well. In general, under Medicare, if you hear, oh, I'm sorry, you've plateaued or you're not making progress, your ears should perk up or alarm bell should go off, whatever it might be, because it might be an inappropriate limitation on Medicare coverage.
Right, and it does seem, a further question was, another person asked, are the facilities correct when they make these assessments, that people are not benefiting from rehab. And I think that, are they being upheld, I think is probably what the question is. And if so, why are they being upheld by the Medicare vendors?
Well, I don't know that they are being upheld, that a limited number of these things go to appeal, and I don't have a record of how it plays out at the appeal. But all I can say is that the material that I've cited, right, it's CMS guidance, right? CMS web pages, claims processing manual, all of those say that progress is not required and that plateauing is not something that should torpedo Medicare coverage. So you're right. I get this question. People say, well, why is this happening, Mr. Carlson? Because nursing facilities like Medicare, right? So why don't they just, great, we'll just get lots of Medicare. It's their favorite reimbursement source anyway. So why is this going on? And I think the answer is that there's Medicare, and on the managed care side, it's just that the managed care plans don't want to pay. So there's that on the managed care side. On the fee-for-service side, it's the Medicare contractors who are pushing back. And I talked to nursing facilities folks, and they say, well, we're getting all this pressure from the other side, from the Medicare side, trying to hold back on the expense. And so that's my best estimation as to what's going on. But in that kind of push and pull, it's just that the residents have to push on their side. There's people on the other side who want to spend less money, and then so it's incumbent upon residents and residents representatives to push back in the other direction. And then again, based on this litigation, based on the regulation, based on these administrative documents, everything that I'm saying is correct, right? That
it should be upheld, yeah.
That is the law.
And yet we have someone on here, Mary Beth, says, my mom just got cut off from her PT and the nursing home said it was because she's not improving, but she needs it so she doesn't atrophy. So making our point, that again, Mary Beth, I would suggest that you call our office and we'll try to give you some guidance there. I think this was answered. What is the best way to push back using the GMO standard? I believe we'll be making this call our office, but also we'll be making this PowerPoint available. I think is that the case? So the legal sites are in there, and again,
people just need to appeal, right? They need to check the box that says submit my bill. They need to push back against the managed care plan, and they also need to talk to the physician and the rehab people to educate them as well and to energize them a little bit. All those things I think are helpful.
Yeah, is there a difference? We did get a question here along those lines. Is there a different approach if you're on Medicaid Advantage? Was fee-for-service Medicaid better at approving these type of things than the Medicaid Advantages because of the utilization management aspect?
Yeah, I can't give you any kind of empirical information. There's some general wisdom is that you might be better off in fee-for-service because managed care has a financial incentive to limit coverage, and so. But I don't want to make just some blanket recommendation that people go fee-for-service. But there is an incentive on the managed care side to limit payment because it's coming out of their own pocket. So there is that risk. And as far as the difference is, I presented on the fee-for-service, the specific procedures relating to fee-for-service. But like I said, there's somewhat comparable appeal rights on the managed care side. You first appeal to the plan, and then the second level is a objective third party outside of the plan that considers the issue. So there's appeal processes under both. Yeah, there's appeal processes under both. So that's the recommendation. You just can't take it lying down. You submit a bill or file an appeal, whatever it is under that particular level, and you also talk to the healthcare professionals to to energize them a little bit, and with some, with some recognition that after the first level appeal, there's some financial risk. So if you get turned down, I don't want to be blind to that. If you get turned down, then you're going to have to pay out of pocket.
Right.
But on the other
And
hand,
that's why people give up sometimes. I think they're a little scared by that.
yeah, and people need to
Weigh that.
To weigh that. But at least initially, the first level, there shouldn't be any risk. And there's that first level of appeal. You get a few days. There's zero financial risk there, and you need to at least push back there and see how far and see how you can do. And again, there's so much misinformation here, like we're discussing already. People are being told, right? Whoever we got a question that said that somebody's mother was told, right, exactly the misstatement that I just said within the last few weeks. The stuff's going on, and
It's so common.
Right, we need to push back whenever we can.
It's so common. Another question was, someone said, our nursing home won't share our loved one's care plan in writing. Is this legal?
No. I mean, the care plan is like a secret thing. It's supposed to be developed by the resident, the resident's representative. The resident's representative can always consent to release of anything, of any of the facility's records. They're the resident's records. If there's any confidentiality, it's to benefit the resident. But yeah, particularly in this instance, it's supposed to be resident-centered. It's supposed to be developed by the resident, and they're driven by the resident and the resident's representative. They can't see it. It doesn't make any sense.
Someone said, can a facility have a rule that Medicare patients do not get single rooms? They must have double, since the facility only has so many Medicare beds. So they say. I don't think that, I think you answered that, is that the payer source should not dictate.
Yeah, first of all, Medicare is usually the high rate. So
yeah, that's what I'm wondering, if this person meant Medicaid.
let's assume they meant Medicaid for a second. That actually depends on the Medicaid rate. So if the state's Medicaid rate is calculated based on shared occupancy, the facility can limit it to shared occupancy. So that's actually an exception to what I said. Depending on how Medicaid reimburses in the state, it's possible that Medicaid will be limited to shared occupancy for those reasons. But I'm not in New Jersey. I don't know exactly how the rate is calculated. So that may be okay. You'd have to figure out how the rate is calculated and what the assumptions are that underlie the rate.
So we want to wrap this up at 8, and there's so many questions, which gives you an idea of just the incredible level of interest in this, Eric, and we really, 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 really appreciate that. I do want to share the comments of one of my fantastic volunteers who says that Common Nursing Home Problems publication has been invaluable to me. I frequently refer residents and family members to this resource. So thank you so very much for creating that and being a national leader. And we're really honored that you're here with us. For the audience, if we didn't get to your question, we will go through the questions and try to see if we can develop answers and get back to you. Again, I just want to thank Face New Jersey for being such wonderful partners, the audience for being such attentive and engaged and interested in this, and of course, Eric, for your national leadership on this and for being a go-to residence for so many a resource for so many tens of thousands of nursing home residents. So thank you so much, Eric. We really are very thankful, and it was a wonderful presentation. So we're going to end things now. Thanks to all of you. And again, look forward to our future webinars that the Ombudsman's Office and New Jersey Face will be hosting in the future. Thanks, everyone.